call, and we'll go ahead and get started. So again, we're going to do disclosures today. Like I said, I usually like to do this one or something similar to it about once a year, just as a good refresher, or if you're newer in the business, hopefully you'll learn a little something today. So um, we'll go ahead and get started. So we're covering three of them. Well, I guess three and a half, if you want to call it that. So the TDS, which is the transfer disclosure statement, the mobile home transfer disclosure statement. So this is essentially the same thing, but for manufactured homes. The SPQ, which is the seller property questionnaire, and the solar, which is for homes with solar. So let's go ahead. And we're going to cover which each of these forms actually requires, the timing rules that create real liability, and how to talk about each one with your seller clients and your buyer clients, because you do have a little bit of a different perspective depending on which side you are representing on this. So let's start off with the TDS and the mobile home TDS, what they are and who is exempt. So every sale of a 1 to 4 unit residential property requires a completed TDS unless the transaction is exempt. And there's not a lot of exempt transactions out there. And, one reason why I like to do this webinar is sometimes when you're on the buyer side, you have a listing agent who maybe doesn't understand the rules and they think that the property might be exempt, and it's really not. So we need to know exactly when a property actually is exempt and when we are gonna, you know, essentially tell the other agent they're incorrect and get that TDS filled out by the seller, hopefully. So in that event. So, and I do see that come up from time to time. So manufactured mobile homes use the MHT TDS instead, which has the same basic rules, same underlying statute. Both of these are statutorily defined forms, meaning the language is fixed by the civil code. We don't get to reword them. We don't get to add in fields or not fill out sections, even if a local addendum covers similar ground. So this is a statutory form. It is a requirement on all 1 to 4 units, again, unless it's exempt, and we'll go over the exemptions. So this applies even to FSBOs, common misconception there, and to transactions using no real estate licensee at all. The seller's obligation doesn't depend on having an agent. This has to do with property transfers, has nothing to do with car forms or hiring a licensee or anything like that to represent. It applies to new construction that isn't part of a subdivision, such as a single new home or a new 1 to 4 unit building, like in an infill lot or something like that. If the property is covered by a public report under Business and Professions Code or falls under an exemption for small subdivisions, then no TDS is required for that specific reason. So, you're taking your client over to go buy a, home from DR Horton or something. No, you're not going to get a TDS there because that is part of a subdivision. It does apply to mixed use property as long as there's at least one, but no more than 4 residential units on it. Whether the property is mostly commercial doesn't matter. The presence of a residential unit is what triggers the law. So if you have, I don't know, one of those kind of townhome looking uh, units, and maybe there's a little store at the bottom, and up top is the residence. I've seen those get built by, builders that create maybe a little downtown area or something like that. That'd be a mixed use property. And it does have a residential on it, so it would be required on that particular sale. Um, An as-is sale still requires a TDS. As-is affects the seller's obligation to repair or warrant the property's condition, not the separate duty to disclose known material facts. And to, embellish on that a little bit, if you're using a car residential purchase agreement, it's already defaulted to as is. So essentially every sale you're doing is an as-is sale, meaning the seller is not promising any repairs and they are not warranting the condition of the property, but they do need to disclose any known defects. Um, Exemptions under Civil Code 1102.2. So none of these excuse the seller from disclosing material facts under general law. And the licensee's duty to visually inspect and disclose the results of that inspection still applies almost every time. So transfers requiring a public report under Business Professions Code. So typically a new home sale in a subdivision of 5 or more units, and transfers exempt from a public report under uh, this other professions code. So that'd be a subdivision of 4 or fewer units entirely within city boundaries that satisfies local requirements. This is pretty nichey right here. You're probably not going to run across this probably ever in your career, but possibly. Um, Court ordered transfers, so probate sales, bankruptcy trustee sales, writs of execution, eminent domain, decrees for specific performance do not require a TDS. So we're going through exemptions right now. Foreclosure transfers, including a deed in lieu of foreclosure, and transfers by a beneficiary who acquired the property through foreclosure. Transfers by a fiduciary administering a descendant's estate, guardianship, conservatorship, or trust. An exception worth flagging to a seller: if the property sits in a revocable trust and the trustee is a natural person who has also, who was also the former owner or a recent occupant, this exemption doesn't apply and a TDS would still be required. Co-owner to co-owner transfers. So, maybe someone's buying the other person out of the property. You're not going to need the TDS there. Transfers to a spouse, a child, a grandchild, any of that, or any direct ancestor descendant. Transfers between spouses in a dissolution, transfers to or from government entity, transfers via the state controller's unclaimed property law, or transfers resulting from a failure to pay property tax. Leases of any duration, unless the lease includes an option to purchase or is a ground lease coupled with improvements. So you can see there are quite a few exemptions, but they don't really apply to a lot of sales. What we generally see is going to be, maybe the probate stuff, and then lately foreclosure. So let me check the checks. I think that was just Paul going back and forth there, but let me just double check. Yep. Okay. So if you have any questions, go ahead and throw them in the chat, please. All right. So next up, section 1. So when you're filling out the TDS, we need to make sure this thing is 100% complete. Otherwise, it can be kicked back from the other side saying, hey, this is not a complete disclosure. I need you to fill it out completely. So right now we're looking at a snippet from page 1 of the TDS. This is kind of at the top of the page 1 there. And this is section 1. This has to be completed. So this is where the seller can note substituted disclosures that already cover the same subject matter as the TDS itself, not just any inspection report. A natural hazard disclosure report, for example, does not count as a substituted disclosure since it covers different subject matter entirely. Flood, fire, earthquake zones, not the property condition items on the TDS. And should always be provided in addition to the TDS. In practice, almost every seller ends up checking no substituted disclosures for this transfer, and that's the right box to check in the majority of transactions. So that's typically what I recommend or advise. If you call me and you say, hey, which one? I'm usually going to say, check that box 3 there. Delivery. So the RPA requires the seller to deliver the TDS within 7 days after acceptance. So that's the default timeline. The manufactured home purchase agreement gives the same 7-day default. Absent a contract saying otherwise, the legal standard is simply as soon as practical before transfer of title. So the 7-day rule is really the practical deadline we work against as agents. Two or more agents in the transaction. So the selling agent, the one who obtained the offer, is responsible for getting the disclosure to the buyer unless the seller gives other written delivery instructions. One agent involved, that agent delivers it. No agents involved, the seller delivers it directly. Delivery in person starts a 3-day rescission window. Delivery by mail starts a 5-day window from the day it's deposited in the mail. Delivery electronically, which is the majority there, starts a 5-day window from delivery. Delivery to the buyer's agent counts as delivery to the buyer under ordinary agency law. And the caveat to that is it needs to go to the email address stated on page 16 of the RPA, where the agents fill out their information and that email is placed there. That is the designated email address. So if you send it to that email address, it's deemed delivered. You send it to any other email address other than that, it could be disputed. The cleanest scenario is a buyer who receives the TDS before signing the offer. In that case, there's no statutory rescission period at all tied to the TDS. Once the buyer signs first and the disclosure shows up after, the 3 or 5-day window clock automatically comes into play. So let's put that into a real scenario. You're a listing agent. You have not had your seller's disclosure signed yet. Offer comes in, or maybe multiple offers come in, and you're wanting them. Maybe it's a hot property, and the buyer's agent is, waiving inspection contingencies, the entire investigation contingency, which is again not advised ever, but let's just say they do it, and you guys come to an agreement, and then you send over the seller disclosures, including the TDS. Well, technically, the buyer has a way out of the contract by TDS law. So it's not truly a non-contingent offer unless the TDS is signed prior to acceptance. So keep that in mind. I don't want to call it a loophole, but I see that quite often in non-contingent offers. I would say those are not that common, but in the non-contingent offers, I see people delivering TDSs after the agreement. And truthfully, that is not a true non-contingent offer at that point because there is a rescission right with the buyer because they received it after acceptance. Um, so the rescission clock, this is the part that actually creates liability. It's the same clock for TDS and the mobile home TDS. So if the buyer receives a disclosure before signing the purchase agreement, there's no rescission period. If the buyer receives it by signing, they get 3 days. Or sorry, if the buyer receives it after signing, they get 3 days personal delivery, 5 days mail, and 5 days electronic to cancel, even if contingencies have already been removed. So since 2019, the TDS isn't legally complete for purposes of this clock until section 1, 2, and 3 are done, meaning completed, all the boxes checked, everything filled in, plus signed. Section 3 is the listing agent's inspection disclosure. If you're sitting on that inspection, and you can hand the buyer a fresh rescission window without even meaning to, because if you're checking in section 3, checkboxing that you're attaching the avid for that, and then you don't attach your avid, well, then this is not complete. And the avid should always be sent prior to contingencies being released. It actually be, if you're on the listing side, you should be delivering your avid with the seller disclosures. Otherwise, if you send it late, maybe the buyer has signed off or something like that, and then you go and send your avid. That is a disclosure of additional material facts, and you can reset windows at that point. So the avid is not to be done, right before close of escrow or with the walkthrough or something like that. It is part of the seller disclosures. So be sure that you're doing that. The right can't be waived. A buyer can't sign it away, and a seller who never provides a TDS at all risks the buyer canceling the contract outright. A buyer doesn't have to state a specific reason to rescind. The statute doesn't require it, though the buyer is still bound by an underlying duty of good faith. So a lot of times when you ask me questions, can we cancel? Can we use this? I say, yes, you can in good faith, because that's how the RPA reads, is the contingencies can be used in good faith based on that contingency in place. So this Richmond versus Hartley shows how far this can run. Hartley had been the property's manager for 2 years and canceled on the eve of closing, citing the seller's failure to deliver a TDS. Both the trial court and the Court of Appeal upheld the cancellation. So let's look at it from the listing side, TDS, mobile home, listing side. So you want to tell the seller plainly, this form is required by law unless they're exempt. And refusing to complete it doesn't remove the obligation. It just exposes them to the buyer canceling later. Get sections 1 and 2 completed promptly and don't leave lines blank. If Avid is being used for the agent's portion, write C attached Avid form on the TDS blanks rather than leaving them empty. Do your own Section 3 inspection and disclosure as soon as practical. This is a step that starts the buyer's rescission clock, so don't sit on it waiting, as it's the easiest way to create a problem for your seller, and you don't want to be the reason, if you're doing a good job all up until the delivery of the Avid part, and then all of a sudden the buyer, is looking to cancel. Well, you don't want to create that scenario because you made an error in your timing delivery. Caught in error before the TDS goes out to the buyer, fix it and have the seller initial the correction. If it's already delivered, prepare a seller's amended TDS. You can write that across the top of the new form, signed by the seller, and route it to the buyer through the selling agent. That restarts the buyer's 3 or 5 day window because it's delivery of new material facts. Relocation companies, REOs, and flippers don't get an exemption for never having lived in the property. They disclose to the best of their actual knowledge and check know where they generally don't know. A lot of times you might see them cross something out or something like that. We need to make our buyers aware that this may or may not have been, properly completed, and what their rights are essentially. So keep a copy. Any licensee involved in the transaction has to retain the TDS or the mobile home TDS for at least 3 years. That applies to all your file documents. That's 3 years. Reassure a nervous seller. Neither the seller nor the agents are liable for an error or omission they didn't personally know about. If it came from a public agency or a licensed professional's report, and ordinary care was used passing the information along. Looking at it from the buyer side, so tell your buyer up front, they have the right to receive this form. They cannot waive it, no matter what the listing agent says or what the seller says. Read sections 2 and 3 against your buyer's own inspection findings. Disagreement between that and the seller disclosed. And what the inspector found isn't unusual, but it's worth pointing out directly. So yeah, you might find an inspection findings being different than what the seller has disclosed. It's also worth noting that seller disclosures are not a substitute for buyer investigation. So it is the duty of the buyer to investigate the property in all aspects. The TDS is just what the seller is disclosing, and the SPQ and the others. Watch for delivery date. If the TDS lands after your buyer's already signed, that's a fresh 3 or 5 day cancellation, depending on how it was delivered, whether or not contingencies have been removed. The seller amends the TDS later, new information, a corrected answer. Your buyer gets another rescission window from the date of that amendment. anytime up to close of escrow. If the seller delivers a TDS at all, sorry, if the seller never delivers a TDS at all, your buyer isn't stuck with the deal. Courts have upheld the buyer's right to cancel for non-delivery. Your buyer doesn't have to explain why they're rescinding. There's no statutory requirement to point to a specific item on the disclosure. Even past close of escrow, a completed transaction isn't invalidated just because the TDS process wasn't followed correctly. What survives is liability. A seller or agent who willfully or negligently failed to comply can still owe your buyer actual damages. Neither seller nor agent are liable for errors they didn't personally know about. If the error came from a public agency or licensed professional's report and ordinary care was used passing it along, good context for the buyer is why didn't anybody catch this? Um, Using Avid the right way, so the agent visual inspection. So the Avid exists because the TDS itself only gives the agent 4 blank lines to describe the results of the visual inspection. Obviously, that is not enough, regardless of the size, the size of the house. So it isn't required by law. It's a tool for satisfying the inspection duty that Civil Code Section 2079 already imposes on the agent. When I say it isn't required by law, we're not saying the Avid. The inspection requirement is required by law. So an agent is required to inspect the property that they are transacting. The Avid is the preferred tool, I guess if you want to call it for that, for disclosing this. Could you use other forms? Yes, you could, but you should use the CAR forms that have been drafted by attorneys and run against the law and everything like that. So use the Avid for your agent visual inspection, attach it to your TDS. Either the listing agent or the selling agent can use it, and both may need to if they're inspecting independently. The Avid divides the property into rooms, living room, dining room, bedroom, one, two, etc. Instead of one open block, which makes it much easier to be specific, which is what we want to do when we're doing the Avid. Fill in every category, don't leave one blank because it doesn't apply, just write NA instead. For example, when there are 3 bathroom fields, but the property only has 1 bathroom, yeah, I'll usually just line through that one and I'll say, NA. No visible defects in a room, right? No visual material defects. Um, Note what you couldn't inspect. This is also important because this does come up sometimes, especially maybe in a garage or a locked room or something. Just say, hey, I couldn't inspect this room because it was locked. So we're not expected to go get a locksmith or kick the door down or anything. Avid also spells out the limits of the inspection itself, so an agent's not going to climb onto a roof or into an attic, for example. We don't have to climb up a steep hill, anything that's going to put us in danger. Once Avid is attached, the TDS blanks in section 3. Um, just say see attached Avid form. Don't duplicate the inspection notes on both documents. Just check the box. That's all you got to do. Beyond the checklist, okay. What else has to be disclosed? So a few TDS items get missed because agents assume the pre-printed checkboxes are the whole story, and they might not be for that house. So question 16 on the current TDS covers more than lawsuits. So since 2014, it also asks whether the seller has made certain pre-litigation construction defect claims or claims for breach of builder's warranty or an enhanced protection agreement, regardless of whether a lawsuit was ever filed. Carbon monoxide detection devices, water conserving plumbing defixers both appear on the checklist as items a property may or may not have. Installing either one is not a precondition of the sale, but the sellers need to check the box accurately. If the home was built before 1994 that hasn't been retrofitted, it might not comply with Civil Code 1101.4. Smoke detector and water heater bracing compliance is built into Section D of the TDS itself. Sellers don't need a separate form for this. They certify compliance as a close of escrow right on the TDS. Cities and counties can require additional disclosure beyond the state form and have been able to since 1990. If a local jurisdiction has its own ordinance, that disclosure comes in addition, not instead of the TDS. So it would be another form. So the TDS would still be a requirement. The mobile home TDS, everything is the same except it has a few extra questions on there that pertain to mobile homes. Um, so the real difference is what's being disclosed: appliance fixtures specific to the home, skirting, tie downs, HCD decal number, instead of built structures, plus the same significant defects and environmental hazard questions carried over from the TDS. So um, I have a couple questions. We just went through the exceptions. Okay. So SPQ, what is it? How it fits with the TDS? So, we always say, hey, we need the TDS and SPQ. Why is that? Is the SPQ, part of the TDS law? Actually, it's not. It's a contractual obligation. So it's not a substitute. It's in addition to the TDS. It's an additional contract required disclosure, not a statutory one. So any of the RPAs you're using all require, well, any of the ones that cover residential property, all require it through their own pre-printed language. So that's going to be RPA paragraph 11A3, but no law forces a seller to fill one out. If a seller doesn't want to provide it, that has to be negotiated out of the contract, usually through a counteroffer. Some agreements bring their own version instead of the SPQ. So that could be the vacant land purchase agreement. Instead that's going to use the seller vacant land questionnaire. Uh, Commercial, same thing. They have their own. So I don't know why you wouldn't want to provide the SPQ. I think, from a buyer's perspective, that could seem a little shady, trying to counter out that obligation. If you're on the listing side and for some reason, let's say that wasn't countered out, which truthfully I've never seen it countered out, and I hope I don't. Um, if the seller doesn't provide it, the seller would be in breach of that provision of the contract because it is in the contract as a contractual requirement. So it does need to be provided. And again, we don't want to put our sellers in any kind of bad position here. TDS exempt transaction, this SPQ isn't required either. Use the exempt seller disclosure form, ESD, instead. Since the RPA ties the SPQ requirement directly to the TDS requirement. So basically it says anytime a TDS is required, the SPQ is also required. SPQ doesn't replace the statewide buyer and seller advisory either. That's a separate optional risk management form. And if it's used, it's given in addition to the SPQ. The SPQ doesn't replace whatever local or broker-specific disclosure documents the office has or local associations already use, like the LAD. Many areas have their own addenda, and for this exact reason, the SPQ is meant to create a statewide consistency, but not to override what's already working locally. So it would be TDS and SPQ together, and then if you're in one of the areas that has additional, um, like the local area disclosure or something like that, that's going to be in addition to, not in place of. So why bother with a second form when the TDS already exists? For the seller, a more thorough disclosure upfront means fewer misunderstandings and less exposure to a claim of misrepresentation or fraud after close. When the anger of an after the fact discovery tends to make everything harder to resolve. For the buyer, the SPQ's more specific section by section questions tend to jog a seller's memory in ways the broader TDS categories don't. So the buyer walks away with more information to price the deal and plan inspection around. and not less. The SPQ's topic run wider than most agents expect. So statutory and regulatory matters, repairs and permitting, structural or system defects, environmental concerns, including mold and water, animal and pest issues, disaster history and insurance settlements, use and occupancy, title and HOA matters, neighborhood impacts, boundary and encroachment questions, and landscaping and pool issues on top of the document paragraph that the catch-all material facts section at the end. So every yes answer requires a written explanation right on the form. This is TDS and SPQ. If there is a yes box, it needs to have an answer. If there isn't room, the SPQ generates the text overflow addendum automatically. If you don't like using that, then just attach addendum 1 to it. You can do that as well. So there's no such thing as a yes answer without an explanation. So if you get, if you're on the buyer side and you receive um, any one of these forms and not everything is filled out, or there are yes answers on there without an explanation, then this is not properly filled out and it should be returned, in my opinion. Now, we don't tell them what to put in there or ask them to correct it. We tell them to complete this because that is an incomplete form if they did not provide the answers. If you're on the listing side, tell the sellers there's no time limit on what they have to disclose. They bought that home brand new in 1970. We need to know everything from that time. So, are you aware covers things they've always known. And no matter how long ago, including things that happened before they even owned the property, if they have actual knowledge of them. The standard advice for a seller on the fence, when in doubt, disclose. We've all heard that. If it's worth asking about, it's worth answering. And an unnecessary disclosure costs nothing, while a missed one can cause a lawsuit. So I like to tell the seller, the state of California wants the buyer to know everything you know about this house, and that's how we're going to fill out this disclosure. A repaired defect is still a defect the seller was aware of. The form is written that way on purpose, covering pets and odors, past or present, landscaping and pool problems, past or present, and neighbor disputes, past or present. A seller who fixed something 2 years ago would still check yes, saying this thing happened. Here's how I corrected it. That's how the explanation would go. It's pretty simple. Paragraph 5 asks for supporting documents, reports, inspection, permits, estimates, including ones from before the seller's own ownership. So get these gathered early, not the week before closing, since the seller has to turn over essentially anything in writing that touches the condition or repair of the property. Relocation companies, REOs, flippers answer to the best of their knowledge, just like on the TDS. If the original owner is still reachable, get their disclosures too, so they can be passed on to the buyer. Shapiro versus Sutherland is the cautionary tale. So an original owner was sued for fraudulent non-disclosure by the ultimate buyer, even though the sale went through a relocation company in between. And if you have the prior disclosures, such as flipping a property, those also need to be turned over to the buyer. So that question does come up quite a bit. Basically, if you're in possession of it, it needs to be delivered. Flip sale, if the seller acquired a property within 18 months of accepting the buyer's offer, SPQ has a dedicated question for it. A yes requires listing every improvement made while the seller owned it, plus contractor names and contact info for any job of $1,000 or more, plus copies of permits obtained, or for unpermitted work, contact information for whoever did it, so the buyer can track the permit down. This is the 2024 Flipper Disclosure Law showing up directly on the form, not a separate filing. So that is section F here on the SPQ. Materially is judged from both sides, not just the sellers. coach a seller to ask themselves, not only does this bother me, but would a buyer care about this, especially for the material facts catch all at the end. The two answers aren't always the same. If a seller wants the SPQ negotiated out of the contract, that can be done through a counteroffer, but talk them out of it if you can. Completing it tends to jog loose any details that actually matter. So I would never recommend that. I would never advise that. Fill out the SPQ. If a seller is kind of being shady about disclosing things, you might reconsider taking that listing because that sounds like it's going to be a problem. SPQ on the buyer side, so it's not a warranty. It isn't a guarantee of the property's condition. It's the seller's good faith recollection framed as "are you aware of?" and a no answer means the seller doesn't know of anything. Not that nothing's wrong. Use it to shape what your buyer asks for: inspections, repair requests, or price adjustments. This isn't a substitute for buyer's own investigation, judgment, or common sense, and the form says so directly. Timing matters here too, and it works the same 3 ways every time. So before an offer, your buyer can factor it into the offer itself. During the inspection period, it can inform whether to remove contingencies, deliver it late, after contingencies are already off, and after TDS has already been delivered. It can be treated as a material fact amendment to the TDS and reopen a right to cancel, even if the buyer already moved every contingency. If your buyer wonders why the SPQ matters, and they're already getting a TDS, the SPQ is designed to jog the seller's memory with more specific room by room, topic by topic questions. Often more than not, it surfaces something the TDS alone wouldn't have done. And I think we're up to 6 pages on that thing now. So it covers a lot of aspects of the home. So for the listing side, very important that we have both of these filled out to the best of our ability. And on the buyer side, making sure we review, especially all of the yes answers, to make sure we have an explanation there. And then, the no answers can be just as important as well. Solar. So the solar advisory and questionnaire applies to any property with a solar power system. So I do see these get missed sometimes coming from the listing side. They're sending over the TDS and the SPQ, which is great, but this is also applied contractually. It exists because solar ownership is more complicated than it looks. A system can be owned outright, owned subject to financing or a lien, a lease, and the financing itself can be secured in ways that don't show up in a normal title search. A solar loan can be secured by a deed of trust, which shows up like a normal lien, or by a UCC1 filing filed with the Secretary of State, which does not appear in a standard property title search. Hero and PACE financing gets collected through property tax payments. So the lien shows up on a tax bill, not as a recorded encumbrance. Plenty of sellers don't realize their solar is lien encumbered at all because of this. Some systems are financed through private loans that aren't secured by the property or the equipment at all. If those need to be paid off at sale, it has to be written in the contract. Multiple seller systems on one property means multiple solar forms. Each system gets its own separate questionnaire, not one combined form. Is that a thing? Yes, I have seen homes with two separate systems where they bought one originally, maybe they decided it wasn't enough power, they had a secondary one put on at a later date. And they might have completely different ways that they're showing up on title or ownership. The purchase agreement's default position is that the solar system transfers with the property and the buyer gets a contingency period to review the actual solar paperwork, the lease, the PPA, security agreement, warranty, etc., and decide whether they're willing to take it on or not. If the system isn't supposed to transfer, That has to be written into the contract as a modification and not assumed. So solar on the listing side, find out what you're dealing with before you take the listing. Is it owned outright? Is it financed? Is it leased? And get the actual documents. Lease, PPA, security agreement, warranty, maintenance agreement, etc. in hand immediately, not after an offer arrives. I know we all get excited about getting the listing, but it is good to gather all of these documents as early as possible, especially because sometimes it takes the seller a while to find everything that you need, and we don't want to be rushing after we, get the offer in, and lo and behold, we can't find any solar paperwork. We need to know this ahead of time so we can try and mitigate that and avoid an escrow cancellation. Check the property tax bill for a HERO or PACE assessment. It's the easiest way to catch financing your seller may not even realize is a lien. System is leased. Get the buyout terms and transferability language from the seller's documents before you list. A solar company's approval is required for a buyer to assume the lease, and that isn't guaranteed just because the seller wants to sell. Ask about a transfer fee. Some systems charge a fee just for the change of ownership, whether the system is owned, leased, or under a power purchase agreement, and it's easy to miss if nobody asks directly. If you're on the buyer side and you see that there is a solar system on the house, you might want to write in there about a solar transfer fee being paid by whoever, buyer or seller, split, however you want to do it, just to cover that because it could come up. If the system is financed and the loan isn't secure on title, flag it for your seller. The purchase agreement may need to be amended so the buyer formally agrees to take on that balance, since it won't show up as a lien the way the mortgage would. Neither you nor the seller are qualified to evaluate the system's technical quality or the legal effect of its financing. Recommend a solar PV system inspector and a real estate attorney for anything beyond natural form language. Solar on the buyer side, MLS listings and marketing materials are not contractual. This has been tried over and over and over again. Just because it says it has it in the MLS doesn't mean it goes with the house. It's whatever is put in the contract. This applies for everything, appliances, whatever. Tell your buyer directly, get the actual solar documents and read them before deciding anything. Don't rely on what the listing says. Buyer wants to assume a leased or PPA system. That requires the solar company's approval. It isn't automatic, and it isn't the seller's call alone to make. Ask whether the solar lien holder will subordinate to your buyer's new purchase loan. Rarely, but it has come up where they would not. Many won't. If they don't, your buyer may need to pay off the solar loan at closing or purchase with new financing on that portion, which can change the whole deal structure. Expect this to potentially slow down escrow. The system is being assumed. Solar company may take steps to protect its own position, and your buyer's lender may require a solar endorsement from the title company, both which take time. Build it into the timeline rather than finding out on day 25 of a 30-day escrow. Ask about the transfer fee specifically. It applies whether the system is owned, leased, or under a PPA. It's not always obvious from the listing. And then again, recommend a solar inspector specifically. Most home inspectors, a general home inspector, doesn't cover the solar system itself. So you may need to get someone qualified for that. The duty underneath all three of these forms, so the TDS, SPQ, and solar, are the paperwork, not the whole obligation. We do need to remember that. California case law imposes a separate duty on sellers to disclose known material facts affecting the property's value or desirability. And Civil Code 1102.1 says TDS statute never meant to displace that duty. A seller who fills out all three forms accurately has done the paperwork right. A seller who leaves something out because it wasn't specifically asked about hasn't necessarily meant the underlying duty, and a buyer can still bring a fraud or non-disclosure claim on facts outside of any forms. So when you're running through those forms, there is a section that says, are you aware of any other known defects or material facts that need to be disclosed? And that's what they're referring to there. So just because it's not asked about doesn't mean it doesn't need to be disclosed. Common pushback and how to respond from a seller. I never lived there. I mean, I hear this one all the time. I never lived there. I don't know anything about the property. It doesn't matter. Fill it out to the best of the actual knowledge and check no where genuinely unaware. Lack of familiarity isn't an exemption, whether the seller is a relocation company, REO, or an out-of-state investor. We're selling it as is, so I shouldn't have to disclose anything. I hear that a lot too. Again, all homes are as is per the RPA, the car RPA. As is changes the repair obligation, not the disclosure obligation. The TDS, SPQ, and solar, if there is solar, are all still required. I already told the buyer about that in person. Isn't that enough? Nope. Get everything in writing. Always get everything in writing. A verbal heads up doesn't satisfy the statute and won't help anyone if there's a dispute later. Can we just leave section 1 blank since there is nothing to substitute? No, you will check no substituted disclosures box instead. Leaving it blank invites an argument the TDS was never completed. From the buyer side, can I get out of the deal for any reason once I get the TDS? Only within the 3 or 5 day window after late delivery, or if there's a genuine misrepresentation or non-disclosure issue. Receiving it on time with nothing concerning in it doesn't create a new right to walk. The SPQ says no to everything, so the house must be perfect. It says the seller isn't aware of anything, not that nothing exists. The buyer's own inspection still matters, and the SPQ says so directly. Why does timing of delivery matter if I'm going to read it either way? Because the date determines the buyer's rights, not just what they know. Early delivery means no rescission period at all. Late delivery can reopen one even after contingencies are gone. On a mobile home or manufactured home deal, does any of this really apply to a mobile home sale? And yes, it does. Same underlying law, same rescission rights. It's just the MHTDS instead of the TDS. So there's a couple extra questions on there. On a solar property, the system is paid off, so there's nothing to disclose. Ownership type still gets disclosed either way. Paid off doesn't rule out an unreleased UCC1 filing or a transfer fee the seller doesn't know about. Especially on some of these older ones where maybe the company went out of business. I mean, some of these things could be a real mess. So getting to know this up front and having the seller fill this out early on is going to maybe jog their memory there. And so you can start digging into this ahead of time. The MLS already says solar is included. Isn't it enough for the buyer? No, advertising doesn't create a contract. The buyer needs the actual documents before relying on anything. Can't the buyer just take over my lease payments? Only with the solar company sign off. That's the solar company's decision, not the seller's or agent's. So that's about it for it. Basically, just a quick review of the most important things we went over. Buyers can't waive the right to receive the TDS, and it doesn't have doesn't have to give a reason to rescind. The TDS isn't complete until sections 1, 2, and 3 are done, including the avid. So don't sit on your inspection. Selling agent delivers when 2 or more agents are involved. Single agent or no agent, that party delivers directly. The SPQ supplements the TDS, it never replaces it. The TDS exempt sellers use ESD instead of SPQ, and you want to verify that it is actually exempt, not just taking the seller's word for it or not just taking the other listing agent's word for it. Error caught before delivery, corrected at initial. Error found after delivery, seller's amended TDS. Any material change delivered after the buyer signs, TDS or SPQ, can open a new rescission window even after contingency is removed. Keep all your stuff for 3 years, all of your files, all your documents. Seller owned the property under 18 months. SPQ requires full improvements, contractors, permits, rundown under the 2024 Flipper disclosure law. Solar financing can be secured by UCC1 or tax assessment instead of a normal recorded lien. So this could be missed. This is why that form is good to fill out so we can figure it out. Assuming a solar lease or PPA needs a solar company sign off, it's never automatic. And multiple solar systems on one property, one solar form per system, not one combined form. Which I guess leads me to another question that comes up sometimes, um, which is the TDS and the SPQ on a multi, a 2 to 4 unit. Obviously, it's going to be one for a 1 unit. I usually tie that to how much work has been done on each unit to the fact that do you need to fill out one of these per unit? So it would say, went through Main Street, Unit 1, and the next form went through Main Street, Unit 2. Um, because sometimes there's been extensive work done in one or more of the units, and you may need to be very specific on that, and in which case you might need a separate TDS or SPQ per unit, just based on, what's happened over the years, especially with extensive remodels and things like that. So that's my recommendation on anything that's going to be 2 to 4 units. So I think that's it. Let me just check the chat. Got one in here. Can the buyer back out of the purchase if they are obligated to pay off a solar financed loan? If it's during the contingency period, yes, because you can say, yes, I want to, I'm going to agree to pay off this loan at closing. And then when the solar documents come through, hopefully with all the seller documents that come through, all the seller disclosures, and they give you the solar agreements and all of that stuff, they may not like the terms of anything else in there. They may not like the size of the units. They might not like stuff that's in there. So they could still have it based on what those documents look like, just like, in any other inspection, I guess, if you want to equate it to that. So they still could, so long as it's in good faith based on the contingency provided in the purchase agreement. So looks like we might have one in Q&A too. How should I disclose pending SB 326 matters? That would be other known material defects in the TDS and SPQ. That's the blanket question kind of there at the end. So if it's not covered in the TDS or the SPQ, then you would just add that into the section that's basically, I know this other stuff about this property that wasn't asked here. So I imagine they'll probably strengthen that up too in later revisions. Went through exemptions. Okay, I think that's all the questions. So yeah, hopefully you learned a little bit today. This recording and this presentation, which is sometimes a little easier to review, if you want to go back and read some notes, all available in the online office under the training and motivation tab. Click that, you'll see all of our previous webinars, and we do include the Google Doc here as well for reference if you don't want to, watch the whole webinar again. So. We also post them on our YouTube channel if you want to find them there, and it'll also go into our Facebook group. So there's 3 different ways that you can find our recordings. But if you ever have any questions, always give me a call, especially with disclosures and things like that. So Hopefully you have a great week, and we will see you next week.